Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for April 11, 2023. Again, all matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we're streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
On page 19, Judge. Alex, may we have Arturo Arellano, please?
Ms. Martinez, do you have, or Mr. Stevens, do you have his, I thought his was 100,000 split bond. Is that what it is?
It is, Judge.
Okay.
50 and 50.
Okay.
Because number 2023-0D00447, State of Texas versus Arturo Arellano. Announcement of council, please.
State Texas represented by Kyle Vance. State's ready.
And Mr. Ariano, I'm representing him, and we are ready, Your Honor.
And Mr. Arellano is appearing remotely from the jail annex. We're set for a bond hearing. Mr. Stevens, I thought we had one about maybe 3 or 4 weeks ago.
Correct, Judge. I think it was March 22nd, looks like.
Okay, you may proceed.
Judge, we're asking the court to reconsider the amount of the surety bond. We're hoping for a reduction to 10,000. And I just to refresh your recollection of the case, there are, I think, 5 counts in this indictment. The parties had a relationship together with one, and they have one child together. And they were living together at the time of the offense in 2011. I mean, 2021. I'm a whole decade behind. So 2021, at that time, she accused him of, on November 6th, punching her on the left arm. However, looking at the photos on Portal, I mean, you can barely maybe see an old bruise. Count 2 says the offender and the victim had sexual intercourse. And at some point she wished to stop, but he finished first. So that's count 2. Then count 3 and 4 were additional allegations of sexual assault while they were living together. And on count 5 is a combination of count 1 of punching in the arm, and then she says that he punched her on the left side of her face, causing her to feel dizzy. And again, the photos on Portal show absolutely nothing on her face. The report says the injury on the victim's arm described as an old bruise was photographed. The victim did not have any visible injuries on her face. Then he stated that they went on November 13th, which is one of the alleged dates in the indictment. They went to Walmart, and on their way, they were in a fight, and he punched her car. He got so upset, he punched her car because she says she does not cry for him. And then at Walmart, she said that the victim held her child when they arrived at Walmart. The offender took the child away from the victim and walked in different store aisles, pretending that he was going to take the child with him. However, the detective got the video from Walmart from that time, and the manager was able to find the parties. It says, the manager was able to follow the 3 individuals throughout the store. I observed the offender and victim from the time they entered to when they left, just over an hour. I did not see anything that would indicate the offender and victim were fighting. I also did not see the offender pick up the child victim and walk away from the victim in an aggressive manner. So that's the officer stating that he did not see what the complaining witness is claiming happened. So in addition, I have photos from his family. That all occurred supposedly in November of 2021. I have photos from his family and statements from them that these two were still together, as you know, in 2022, living together, and they have photos of them happily together. So that, at the very least, would indicate he's not a danger to her, or she wasn't afraid of him throughout all of that time. So that's one of the grounds for a bond reduction, is he's not a danger to the complaining witness or to society. And based upon his record and the allegations in this case, that is not an issue. The other issue is whether or not he's a flight risk. And my client lives in El Paso. He's a U.S. citizen. He would be living with his grandfather and grandmother on Nottingham if he's released, and he will not be with this complaining witness. And he is also in agreement with having even no contact with his own son unless it's court ordered. So I do not believe he has any criminal history whatsoever. And due to the nature of these allegations, which even the photos and the police detective cast some doubt on it, I foresee that this case is something that is probably going to wind up in trial, and that he would just have to sit in jail until then. So we're asking the court again to reconsider the amount of the surety bond. We're hoping you could reduce it to 10,000 or less on the surety portion. And I understand we can't have a straight PR bond on this type of allegation.
Okay. So I think the majority of that is what I heard at the last bond hearing. Was there something, Mr. Stevens, that was different?
Yes, Judge, his family has been very faithful about contacting me. I mean, almost every other day I'm hearing from them. They want to bond him out. They simply do not have the property to do so. So at $50,000, they would require surety. It would require, a collateral. So I think they could come up with some cash to get him out, but they don't have the type of collateral that would be required to get him out. So from the last time I heard, I think bondsmen require collateral for anything above $20,000. So that's just going by past hearsay. So that's really what's different.
Okay, Mr. Vance.
Yes, Your Honor. I mean, the rendition of facts are a little different in that I know November 3rd or 4th, there's a first sexual assault. November 6th is that the complaining witness received a message from another man. The defendant was upset, punched her in the left tricep area, grabbed her by the hair and yanked her to the ground. Now the sexual intercourse they were having, yes, she did tell him to stop because she was hurting, and he grabbed her by the arm, said, "You're not going anywhere." And he said he's not going to stop until he finished, and that she belonged to him. The last sexual assault was on November 11th. And November 13th, the complaining witness confronted the defendant about leaving the child alone in the bed, and she was trying to break up with him. He says, you think I'm going to let you go? He locked the door from the inside, stood in the front door. Complaining witness told him, "Please, if you let me go, I won't call the cops." He goes, "You're not leaving me. You're not going to work." Then kicked her in the leg, grabbed her by the hair, yanked her to the ground. She stood up and grabbed her child. Defendant punched her in the face. Complaining witness says after the punch, she felt dizzy, had a blind spot. For some reason, I don't know if it was intended or
down
not.
a little bit, Mr. Vance. Just keep going.
Yes, ma'am. And then for some reason, I don't think he was trying to punch the child, but nevertheless, the child was punched by defendant. And then the complaining witness, she feared for her life and her child, and she requested emergency protective order. Now, just because they were still together at some point, I mean, we know the cycle of family violence in the situation, and she may have not felt free to leave or to be away from him, and just kind of going along with that. So I don't think really that the pictures together can indicate that she wasn't in fear of her life anytime during that time, or in fear of safety of her physical being.
Let me ask Mr. Vance. I do recall a lot of what your colleague Ms. Elizalde represented there. What's the wreck? Is there a wreck on this case?
The wreck on this case, we were waiting to contact the complaining witness for this wreck this week. That was entered in Monday, but I can get one today for the defense on this. I don't. Yeah, I don't know why we need to make contact anyway.
So Mr. Stevens, go ahead. I feel like you're going to say something.
I don't foresee my client accepting an offer on this case. I would also like to ask the DA, I have a picture from Porto from November 14th of the alleged punch to her face, which she says practically made her dizzy. It was so strong. And I think we should offer that into evidence. It was taken on November 14th, the day after. And you literally cannot see anything.
I don't know if you're making or asking to have that admitted in terms of the bond hearing, Mr. Stevens.
I think, well, go ahead, I'm sorry.
I certainly take your representation, but if you'd like to admit it, then for purposes of this hearing, I guess happy
That's fine, Judge. I'll just await your ruling then.
Okay. Yeah, no, I don't see anything different here. So the request is denied. The bond will remain the same. It was split in half from the last consideration of the bond. Yeah, no, so it'll stay as is. We're set for jury trial in August. If you all are negotiating, talking, if there's something that I remember the state being opposed to any reduction, even on the last setting. So if something changes and you think there might be a circumstance that would affect a decision on the bond, then happy to hear it. But for now, the request is denied.
Okay, well, thank you for hearing us again, Judge.
Absolutely. Who's next?
Mr. Stevens, are you also covering Eaton?
I am sorry, Mr. Marufo, can you repeat that?
Is your client Eaton also? William?
No, I do not have anybody else. What was the full name?
William?
I wonder if we need Mr. Huffman in the interim, we can take care of Mr. Macias.
Yes, Judge.
Mhm.
And next, may we have Ortiz, Noah Ortiz?
Let me right out.
Thank you. You've been all month.
Yeah, I'm wondering about that connection, Mr. Macias. It looks like.
Judge.
Mhm.
I'm here at JPD. I should have a good connection to you. Can you hear me?
I can hear you right now.
Okay,
Let's
good.
see if we do. Ms. Martinez, and maybe Mr. Macias, you can help me here. In terms of the bond amounts, 4484, the cruelty case, I have that at 10,000. I have 4309 at 25,000. I have 0480 at 100,000 and 3180 at 1,500. Does that sound correct?
That
Yes,
is correct, Your Honor.
Beautiful. Let's get started.
And, okay,
Go ahead, Mr. Marufo.
In cause number 2022-0D04484 and 2022-0D04309 and 2022-0D00480 and 2022-0D03180. The state of Texas versus Noah Roman Ortiz. Announcement of council, please.
Sorry,
City
would-
of Texas, represented by Kyle Vance.
Would you give me the last case number, please? There's some little interference.
In cause number 2022-0D03180.
good afternoon, Judge Perez. Francisco F. Macias, representing Mr. Noah Roman Ortiz on all four cases of which you have called the cause numbers. And I talked to Mr. Vance prior to this, and I told him that we had sent a cruelty to non-livestock animals in 4484 that said, well, I don't know if it said, but she said she wanted a non-prosecution statement. And I talked to my investigator, and she's willing to give us a non-prosecution statement saying that he wasn't even there when it happened. So I was wondering if you could reduce that to 10,000 PR, period. And then we also had a non-prosecution for the assault of a pregnant person. I was wondering if you could reduce that to maybe 25,000 PR. The controlled penalty group 1, I guess it should stay at 1,500 cash or corporate surety. And I was wondering what you could do about this $100,000 bond. You know, when I saw it, what I want to say is he didn't kill anybody. And I was wondering if you could reduce it substantially.
So let me ask a couple of things, Mr. Vance. Let's work through some of these. 4484, which is the cruelty case, that is at 10,000. I guess is there a Mr. Macias, you're referencing, it sounds like a female. Is it the same individual involved in any of the other cases? Because I have assault.
No, I think this is completely a separate individual from anything else.
Okay. Okay. All right. So let me hear your position, Mr. Vance.
Judge, I on the cruelty to non-livestock, I'm not opposed to some kind of reduction of bond. I think that a purely PR bond is a little much, and especially for the assault of pregnant person and the assault of family household member, because there's previous convictions in this, and regardless of the non-pros on one of the family violence, I just think that there's an issue of possibility, of dangers to the witness, and when there's non-pros. I don't mind some kind of reduction, but I just think that these pure PR bonds are a little much for these type of charges.
So I'm looking, let's see. Ms. Martinez, I thought I had the PR rebel. So clearly the 100,000 is the
Yeah, I believe it's 4.8
high bond. I'm seeing the capias for the drug case, pardon. So he was on the drug case. Make sure I have the right one. They pulled his bond in JMAG because he was placed on PR bond in 2021. He failed to report and they pulled his PR bond in May of 2022. Then he was arrested in July, and he was granted another PR bond in July of 2022. He was placed under intensive supervision to report bi-weekly. He failed to report since July 2022. Our office made several attempts to contact him with no success. He has failed to comply. So he hasn't done well on PR bond. Let me see. What I'm looking for is the one that I would have signed. Their CCR2 has the same revo. Ms. Martinez, do you happen to have the PR revo KPS on the case? Let me see. 0480, that's the AFV with a prior conviction.
Let me go ahead and send that to you, Judge.
Thank you. So, Mr. Macias, just, looking at those, it's not a very good case for your client in terms of his performance on PR bond. Do you know anything about what his issues were? Because it's not just that we're having, well, that was the next question I had. Mr. Vance, can you go through and tell me what the dates of offense are for each case?
Sure, Your Honor.
Thank you.
I can tell you the date of offense, Judge. On the assault on a pregnant person, it's 10/6/2022. On the cruelty to animals, it's 08/12/2022. And then on the assault family household member previous conviction, it's 03/02/2021.
Those are correct. And then the possession of a controlled substance was 12/3/21.
Correct.
03/21. Okay, so we have the AFE with a prior. And then he picks up the drug case. And then he picks up the cruelty and then an assault on a on a pregnant person. Are the victims in the two, the assault of a pregnant person and the AV, are those the same individual or are they different individuals?
I think that they are the same person.
Can you look at that, Mr. Vance?
Yes,
While
Your
we wait on that, so what's the issue, Mr. Macias, with your client not reporting to PR?
I don't know, Your Honor. We could ask him.
Okay, would you like to ask him some questions?
Sure.
Go ahead.
Mr. Ortiz,
Yes, sir.
what's the problem on reporting to PR? They're not real strict. They let you report by phone, don't they?
Yes, sir.
So
I was
what's the
homeless,
problem?
sir. I was homeless. I was high. I was homeless. I was high as well. I wasn't thinking right. But I did not hurt that cat. I wasn't even around, you know what I'm saying? I wasn't even there when that happened. So I was
I know,
homeless.
and the judge knows. I'm more concerned about the assault of the pregnant person and why you didn't report to PR bonding. Because you were homeless and because you were high? Is that your reason?
Yes, sir. That's my reason. I wasn't thinking.
Okay, I think I have enough there, Mr. Macias.
And they're
All right.
both Destiny Mesa, who are the victims are the same victim.
It's the same person on those two assault cases.
Yes, Your Honor.
All right, so on 4484 and 4389, the request is for a straight PR bond, not asking for a reduction, I guess, on the drug case. And then, so I've heard a little bit in terms of, I guess, what is lack of financial resources, Mr. Macias? Is it fair to say that he doesn't have any resources towards the bond?
Correct, Your Honor.
Yeah. So, respectfully, each of those requests is denied.
Thank you, Your Honor.
You're welcome. Thank you, Mr. Ortiz. Who's next?
Top of page 20, Judge.
Mhm.
Annex, may we have Eaton William?
Yes, sir. Give me 1 second.
You okay, Mr. Huffman?
I'm fine, Judge. I was so busy, time was flying by. Sorry I'm late, Judge.
All right, go ahead and call him, please.
In cause number 2022-0D0 2510 and 2023-0D0 1193, State of Texas versus William Eaton. Announcement, counsel, please.
The state of Texas, represented by Kyle Vance. The state is ready, Your Honor.
Rick Huffman on behalf of Mr. Eaton, we are ready.
All right, and Mr. Eaton is appearing remotely from the jail annex. We're scheduled for final hearing plea deadlines on both of these cases. I will tell you that the 2023 case, I think I just wanted to make sure that was added because this is a very new case to today's docket. That is, but the new case is an evading with a prior conviction. So what's the date of offense on that one?
On the 2023, it's March 22nd.
Oh, okay. All righty. So, Mr. Vance, had there been an offer on the 2022 case?
Yes, Your Honor. We have offers 15 TDC, and it's a super first and a third degree felony.
Okay. So I don't know that we can do this. I mean, had you been able to communicate that offer on the 2022 case, Mr. Huffman? Did you have a sense, I guess, before we had the evading, what was going to happen there? Were we going to trial? I mean, you've
I
overseen
figured we were
trial.
just so far off, Judge.
I'm sorry?
I figured we were so far off. I didn't know if that was like a realistic offer. I was hoping for something, you know, that we, you know, these cases are, it's just failure to report. I didn't see any super first. Maybe I'm missing something here. But they're just like address, like didn't report the address and stuff like that. So I thought that was a little high for this type of allegation. But I didn't know that we had this evading coming down. And but I think now that I mean, is 15 the real offer? Is that you know, I was hoping that.
Well, it's the minimum for the super first. I'm sure we can. There's a little bit of some room in there. There's some room in there, but I mean, that's just because there's a previous conviction already of failure to register. And
Had you all negotiated before today, Mr. Huffman?
You know, I've sent some emails to Miss Elizalde and just said, hey, you know, I don't remember exactly what we discussed, but yeah, yes, Judge, we've talked about it.
I guess I'm asking, had you made a counter up until this point?
No.
Because he is actually the longest incarcerated defendant set for trial this week.
And Judge, I'm not really hoping we can go to trial at this point, especially since that he's got a new case that's just been indicted. One that I would consider has more teeth than the failure to register cases. But yeah, so Judge, I'm hoping we can get a continuance. I did intend on filing a motion for continuance.
Well, I don't see one here, and we had a final hearing plea deadline on March 7th. That I believe you were given 30 days to come up with some type of resolution, and I'm not hearing any. And your client is in custody.
I don't see us. I mean, I'm looking at the emails from between myself and Miss Elizalde, and
Hold on. How can that evading be date of offense March 22nd? Is it 2023?
that sounds very fast.
I mean, he was in custody. He's been in custody for like 290 some days.
It's actually, I have a evading arrest is 6/23 of 22.
Okay.
I was in custody.
yeah, it was in June. The allegations that it was in June of 2022.
Okay.
2022.
It's the same off its state as the failure to comply with 6.
Okay.
So I think he was.
It was just delayed in getting it indicted.
Yes, Your
All
Honor.
right. So, I mean, that doesn't really, I mean, if 15 TDC has been there, I mean, if you're going to file your continuance, I don't know. Is the state ready?
The state's, I believe we have all the documents we need for it. I have no problem after this is trying to sort something out. I mean, it's the failure to register is a pretty much a paper case. So either we have it or we don't. So I'll try to see if we can resolve this. But I mean, we didn't make the law making a super first. That just is what it is. But I will call Mr. Huffman as soon as we get off here, see if we can get it resolved.
Let me double check. So this is our second setting. He's been indicted since June. All right, let's see. Motion to reduce bond. Let me just go through some of these. And there really hasn't been anything. Nothing has happened. I mean, the state filed a notice of extraneous, written notice of prospective witnesses. You all haven't really done anything. So, yeah, you're going to get jury sheets. Mr. Huffman, I'm going to schedule him for 11 a.m. on Thursday.
Very
In
well.
person. All right, on both cases. Okey-doke. All right. We're adjourned on these two cases. Thank you, Mr. Eden.